Hello everyone. In this video we will discuss about what is the law on recusal and why there has been a recent fuss about this recusal. You know that recently Arvind Kejriwal, the leader of Aam Aadmi Party, has sought recusal of Justice Swarnkanta Sharma of the Delhi High Court, who is hearing his liquor policy scam case, and therefore, according to Arvind Kejriwal ji, he has solved the recusal of Justice Swarnkanta Sharma ma'am because according to him, Justice Swarnkanta Sharma ma'am might not be impartial while hearing this particular case. So in this context, today we will discuss about a recent article which has been published in the Hindu. Name of the article is A Recusal Test the Delhi High Court Failed, and the author of this article is Kalishwaram Raj. And in this article, we will discuss and understand about what's the law on recusal and what are the principles that when a judge is faced whether to recuse himself or herself from a particular case, what are the principles to be followed in that particular case. So these are the things that we are going to discuss in this video. So let us just start. So given the context of the Delhi liquor policy case, the refusal of Justice Swarnkanta Sharma ma'am to recuse herself from this particular case, the author has argued that this refusal is a deviation from established Indian legal traditions regarding how judges should handle potential conflicts of interest. So, according to the author, this is a deviation from the norm that whenever a judge is called on recuse from a particular case, generally there is a tradition that judges do recuse themselves from that particular case. But in this case, Justice Swarnkanta Sharma has specifically denied the plea for recusal, and therefore the author says that this is a deviation from the established Indian legal traditions regarding how judges should handle potential conflict of interest, because recusal is sought by a litigant only when there is some sort of conflict of interest, when the litigant is apprehensive about any sort of conflict of interest on the part of the judge. And in this case, according to the author, it is a violation or the deviation from the established norms of recusing from a particular case, which has been followed in this country by and large since so many years. So the author in this article discusses about several grounds of recusal that were raised by Mr. Arvind Kejriwal in his recusal plea seeking the recusal of Justice Swarnkanta Sharma. And the first ground was prior findings. According to Mr. Kejriwal, Justice Swarnkanta Sharma had already made some adverse remarks against Mr. Arvind Kejriwal in some earlier proceedings regarding the same case. According to Mr. Arvind Kejriwal, the second ground is the ideological ties. According to Mr. Kejriwal, the judge in this particular case, Justice Swarnkanta Sharma, has attended 4 times an event organized by Adhivakta Parishad, which according to Mr. Arvind Kejriwal is an organization which is affiliated with the RSS or the Rashtriya Swayamsevak Sangh, which according to Mr. Arvind Kejriwal is his political rival. And therefore, Mr. Kejriwal feels that Justice Swarnkanta Sharma might not be impartial in hearing his case in this particular instance. The third ground, which was raised by Mr. Arvind Kejriwal, was the family conflict ground. According to Mr. Kejriwal, the children of Justice Swarnkanta Sharma are panelled advocates of the central government, and they have been allotted cases by the Solicitor General in this case between the year 2023 to 25, and they have been assigned so many cases by Mr. Solicitor General, who is representing the opposite party in this case. And therefore, according to Mr. Arvind Kejriwal, Justice Swarnkanta Sharma might not be impartial in hearing his case in this particular instance. Kejriwal has also made reference to some statements that were made by the Home Minister, suggesting that the outcome of this case is already decided, because Mr. Home Minister in this case has said that Arvind Kejriwal is going to lose his case in the High Court, and therefore Arvind Kejriwal is apprehensive whether the judge in this particular case is going to be neutral while hearing his case. So the core argument of Mr. Kejriwal is there is a reasonable apprehension of bias on his part, because he feels that Justice Swarnkanta Sharma might not be impartial in hearing his case, and therefore, according to Mr. Kejriwal, Justice Swarnkanta Sharma should recuse herself from this case, because according to Mr. Arvind Kejriwal, he has a valid reason to fear that he won't get a fair trial. So now let us just come to the main point of discussion today, that is the law and ethics of recusal. The author explains that recusal law in India is not a written law. Rather, there are some ethical standards that are to be followed by a judge while hearing a particular case and while hearing a plea of recusal. So if we look at the historical precedent, there is a 19th century British case. The name of the case is Leeson versus General Counsel. In this case, it was held that judges must be like Caesar's wife, It means that there should be ever suspicion, which means that there should be not even an iota of suspicion raised on the integrity or the character of a judge. The litigant should not have any sort of doubt in his or her mind regarding the integrity of the judge. And if there is any apprehension in the mind of the litigant regarding the neutrality or impartiality of the judge, in this case, it is better for the judge to recuse. And the golden rule, which was established in the case of R versus Sussex Justices 1923, the golden rule is that justice should not only be done, but should manifestly and undoubtedly be seen to be done. It means that justice should not only be done, but rather it should also appear to have been done. It means that the litigant should not have iota of doubt about whether he has been served with justice or not. And the international standards that are also called the Bangalore Principles of Judicial Conduct that were laid down in the year 2002. These are the golden standard principles regarding judicial ethics and judicial propriety. And these Bangalore principles emphasize upon the independence and impartiality of a judge and the propriety of a judge. It means that the judge must avoid even an appearance of impropriety. It means that there should be not even an iota of doubt which is cast upon the impartiality of a judge. The judge has to be neutral and the litigant must also feel so. And according to the author, the judge of the Delhi High Court in this particular case has ignored these principles. And if we look at some precedents that have been set by the Supreme Court of India regarding the principle of recusal, that means when should a judge recuse himself or herself from a particular case? So there are three specific cases regarding this principle. The first case is Ranjit Thakur versus Union of India. In this case, the Supreme Court has held that the test for bias is not whether the judge thinks they are biased, but whether the litigant has a reasonable apprehension of bias. It means that the judge does not have to look in his mind whether he or she is biased or not, but rather the judge has to look at the mind of the litigant, that whether the litigant has a reasonable apprehension of bias against him. And if it is so, then in that case, the judge necessarily has to recuse himself or herself from the particular case. The judge does not have to form an opinion about his integrity, that no, I am extremely unbiased. The judge does not have to look in his mind, but rather he has to see the mind of the litigant. And if there is any suspicion in the mind of the litigant, the judge has to recuse himself or herself in this particular case. And if we look at the doctrine of precedence, which means that the judgment of the Supreme Court is binding on all the other courts in India, this judgment of the Delhi High Court in this particular case, in which Justice Swarnakanta Sharma has refused to recuse herself from this particular case, is in contravention to the principle of stare decisis, because the Supreme Court has already laid down that the judge does not have to see whether he or she is biased or not, but rather the judge has to see the mind of the litigant. And if there is a suspicion in the mind of the litigant, the judge necessarily has to recuse herself from this particular case. And the same was held in the case of P.K. Ghosh versus J.G. Rajput 1995. In this case, the Supreme Court held that if a litigant has a reasonable basis of concern, the judge should step down to maintain the public confidence. It means that it is the duty of the judge to maintain public confidence in the judicial system, and therefore, if there is a suspicion in the mind of the litigant and there is some reasonable basis for concern, then the judge should step down just to maintain public confidence in the judicial system. And similarly, in the case of State of Punjab versus Dalvinder Pal Singh Bhullar, the Supreme Court said that mere appearance of bias is enough to invalidate a judgment. It means that even if there is iota of suspicion laid on the impartiality of a judge or on the impartiality of the judgment, that is sufficient to invalidate a judgment. It means that the judge has to be impartial in every case and there should be no suspicion raised on his impartiality. So now let us just understand what is the reasonable litigant test, which means that what test should a judge follow when he or she is faced with the question of recusal. So in this case, the author cites a 2015 case. The name of the case is Supreme Court Advocates on Record Association versus Union of India. And the author says that to clarify the simple question, would the judge's participation cause a reasonable doubt in the mind of a fair-minded member of the public? Which means that what the judge has to see is whether a fair-minded person of the public, an individual member of the common public, is going to have any sort of reasonable doubt about the impartiality of a judge. And if it is so, then in that case, the judge should recuse himself or herself from that particular case. The author says that unlike administrative role, where there is a doctrine of necessity, in the judiciary there is no doctrine of necessity because there are several other judges that are available to hear a particular case. And in this case, in judiciary, there is no doctrine of necessity. Whereas in administrative roles, the person might be compelled to hear a particular case despite having any sort of allegations leveled against his impartiality, because there is a doctrine of necessity which says that there is no other person available to do the job. But in judiciary, there are other judges who are readily available to hear a particular matter, and therefore there is no problem for a judge to recuse himself or herself from a particular case. The next point which the author discusses in his article is the challenge of self judging, which means that according to the author, there is a major flaw in the current system, because it is that judge whose recusal is out is the one who is going to decide whether he or she should step down or not. And in this context, the author quotes Justice Benjamin Cardozo and says that we can never see things entirely objectively. We always see through our own eyes. It means that whenever a judge is called upon to hear a plea of recusal, and in that case, there is a very great possibility that the judge is not going to see entire things objectively. He will always see the things through his own eyes, and that happened in this particular case also, because the judgment that was given by Justice Swarnkanta Sharma, she has in various instances defended herself, and therefore the author says that there is no need for a judge to defend herself in a plea of recusal. What the judge has to do is to look entirely objectively whether he or she should recuse himself or herself from that case. The judge does not have to see or apply his mind or to look into his integrity, and therefore the author says that Justice Sharma should have at least let another judge to decide upon the recusal plea to ensure the objectivity in this particular case. And the author criticizes the judge's reasoning for staying on the case. The author says that the judge claimed the suspicion of bias was manufactured and that she defended her children's right to earn a living as a lawyer. The author suggests that the judge's tone in this particular instance was defensive and argumentative rather than analytical, mistaking personal criticism for an attack on the entire judicial establishment. It means that the author suggests that there was no need for Justice Swarnkanta Sharma to play a defensive or argumentative role, because if a judge is questioned about his impartiality and if he is questioned for deciding on a plea of recusal, the judge does not have to play defensive or argumentative. Rather, he or she has to see objectively into the mind of the litigant. And if there is even an iota of suspicion in the mind of the litigant, it is better for the judge to step down in that particular case. And there is no problem in that. But according to the author in this particular case, Justice Swarnkanta Sharma has mistakenly took personal criticism for as an attack on the entire judicial establishment. According to the author, that was not the case. And in the final paragraphs, the author notes that Mr. Kejriwal and Mr. Manish Sisodia have since refused to participate in the further proceedings before this judge. And the author concludes that the judge made a legal error by requiring actual bias to be proven. But that is not the case. That is extremely contrary to what the Supreme Court has laid down in the cases of Ranjit Thakur, etc. Because the Supreme Court has said what has to be proved is only a reasonable apprehension of bias. The litigant does not need to prove an actual bias. But in this case, Justice Swarnkanta Sharma in her judgment has said that actual bias has to be proven according to the author, and this is patently wrong, because according to the author, by staying on the case, the author believes that the court has set an embarrassing precedent for the Indian legal system. I hope you like the video, and do comment your opinion about whether Justice Swarnkanta Sharma has delivered a correct judgment or whether she should have stepped down in this particular instance. What are your thoughts on this? And do like and subscribe this channel for more such informative videos on law. Thank you.